So, very good evening, my dear friends. And today I want to give an explanation and analysis on different kinds of companies because prospectors, promoters, all the important issues we have covered. We will now take care of the different kinds of companies. What does it mean? The companies are primarily classified as private and public limited companies, two kinds. However, there are different segments in which the companies, both private and public, are under different headings. So it is necessary to look at this classification of companies. So, friends, prima facie, the companies are to be classified as incorporated and unincorporated companies. Incorporated and unincorporated companies. Incorporated companies are many under different segments. Unincorporated companies come under section 464, which is technically called illegal associations under the Companies Act 2013. Friends, we will now take up the incorporated companies. The incorporated companies are again under different categories. The first category is the chartered companies. That is the British Charter. The companies were incorporated like the East India Company, the Bank of England, the Hudson Bay Company. They were all the chartered companies which were brought into existence by a special royal charter. You know that the Hudson Bay for the other part of the world and then for East India, the East India Company were incorporated, and Bank of England, of course, for the England. And then these particular companies ruled the world. You know that. Then, friends, the second category of companies are called the statutory companies. That means the companies are brought into existence by special statute, enactment. As for example, the State Bank of India. In fact, banking business can be carried through corporate entity, and SBI is a company. Andhra Bank is a company. Bank of India is a company. So here also the case that the State Bank of India was brought into force by a special statute, that is the State Bank of India Act. In the same way, the State Financial Corporation Act. It is a company. And to what extent the provisions of the Companies Act are applicable is stated under this particular statute, that is the State Financial Corporation Act. This is how there are several other statutory companies. Then, friends, the next category is called the registered companies. Registered companies means they are not by royal charter, not by a statute, but by registration. I have already told you. That is by fulfilling the various requirements of the Companies Act 2013. The company is registered, issued a certificate of registration by the Registrar of Companies. So that is called registered company. These registered companies are twofold. One is the companies existing before 2013 Act and the companies registered under the Companies Act 2013. These are all the two most important aspects you are supposed to see. Then, friends, these particular registered companies once again are multifold. They are multifold. How? As for example, they are registered as companies limited by shares, or registered as companies limited by guarantee, or they are registered as unlimited companies, or they are registered as government companies, or they are registered as holding and subsidiary companies. And then, in all the cases, whether they are limited by shares or guarantee, as the case may be, they are again private and public. They are again private and public. So as for example, you please see the company is limited by shares is explained under section 2, subsection 22 of the Companies Act. What does it say? A company limited by shares means a company having the liability of its members limited by the memorandum to the amount, if any, unpaid on the shares respectively held by them. For example, if a company is limited by shares, then in the event of winding up, the shareholders will lose to the extent of their contribution on their respective shares, and if there is any unpaid amount remaining on the shares they have purchased, they have subscribed, then that unpaid amount is liable to be paid. This is the concept of companies limited by shares. So it says that companies limited by shares means a company having the liability of its members limited by the memorandum to the amount, if any, unpaid on the shares respectively held by them. So the liability is limited to the unpaid share amount. Otherwise, the shareholders will not be called upon to pay any amount, and once the dues, statutory dues and other dues are cleared at the time of winding up, if any amount remains, then that amount will be paid to the shareholders towards their share capital. Otherwise, share capital is not refundable. Right? If share capital is refundable, then it amounts to purchase of their own shares by the company. So question of refund will not arise unless it is redeemable preference share capital. This is the most important aspect. Then friends, this particular company limited by shares under section 2, subsection 22 of the Companies Act 2013 is again could be a private limited company or a public limited company. What is a private limited, public limited? I will tell you at the last. Then, second one, a company limited by guarantee. And then, a company limited by guarantee is covered under section 2, subsection 21, read with section 3 of the Companies Act. The Companies Act refers to a company to be incorporated by shares, guarantee, and unlimited. By section 3, read with section 222 for limited by shares, 221 limited by guarantee. What is limited by guarantee? Instead of shares, the guarantee amount is given by the shareholders. It is that simple as that. 2 subsection 21 says a company limited by guarantee means a company having the liability of its members limited by the memorandum to such amount as the members may respectively undertake to contribute to the assets of the company in the event of its being wound up. So it is the amount by the memorandum the members may respectively undertake to contribute to the assets of the company in order to winding up. So that is called guaranteed amount. A company could be having both shares and guarantee also. Both can be done. Now, this is under section 3 read with 221. Now the third one is a company with unlimited liability under section 3 read with section 2 subsection 92. What this 92 says? An unlimited company means a company not having any limit on the liability of its members. Like the sole proprietorship, like the partnership, the liability of the members is unlimited. It can go to the extent of their personal properties. It could be put on auction. So, their properties could be brought to attachment. This is the way the unlimited liability concept comes into picture. Very rarely you find this type of companies. Most probably, I think they are different and non-exist. Even though a provision has been made, to my knowledge, I have not come across any kind of unlimited company so far. Maybe in the entire country where we have got so much of population. It could be there. I don't know. Now, friends, Section 3 refers to company limited by guarantee, limited by shares, unlimited company, and the explanation is 222, 221, 292 sections. Then, these companies could be again a private company or public company, a private company or a public company, as the case may be. Now, the next category I told you, Section 2, subsection 45, is the government company. Government company means any company in which not less than 51% of the paid up share capital of the company is held by the central government or by any state government or governments, or partly by the central and partly by one or more state governments, and includes a company which is subsidiary of such a government company, is a government company. So the criteria is that the 51% is held by any of the governments. It is a government company. And that government company can be a public limited company or a private limited company. In that event, what is the speciality of a government company? There are certain exemptions. There are certain compliances required. For government companies, sections 394 to 404 specifically deal with the do's and don'ts. Sections 394 to 404. This is the most important aspect. Why? Because there are do's and don'ts. Like, for example, 394, there is chapter 23 of the Companies Act 2013 contains the provisions of government companies from 394 to 404. Briefly, I tell you, the annual reports have to be laid before the Assembly or Parliament, and the report has to be given by the Comptroller and Auditor General of India, section 394. And then 395 is on annual reports where one or more state governments are members of companies. Before all the governments, it has to be put on. Then, friends, after 395, the registration and fees, admissibility of documents, and then inspection, the electronic form, fees for filing, fees to be credited to public account. These are all the things which are common to all companies, which is laid under chapter 24. But the most important thing is that the section 394 and 395 are the most important provisions directly relevant for this particular government companies, 394 and 395, wherein the state legislatures will scrutinize the annual reports, and then the appointment of auditors also will be considered thereon. Basically, this is under chapter 23. Of course, other provisions could be common, and the government companies may, central government or state government may give appropriate exemptions to the government companies, as the case may be. Then, friends, so again, government companies could be public or private. So now we have seen companies limited by shares, guarantee, unlimited, government companies. This is under incorporated companies, where chartered, statutory. Then registered companies, under registered companies existing before 2013 Act, after 2013 Act. And then under that again registration is concerned, it could be registered as limited by shares or limited by guarantee, unlimited companies, government companies, then holding and subsidiary companies. What is it? Section 246 contains the provisions regarding holding company. What is a holding company? What is a subsidiary company? If suppose I have a company I am the managing director of A company. A company has incorporated B company. B company incorporated C company. Now what happens? B and C companies are subsidiaries of A, and A company is the holding company of B and C. I hope now you understand. Like I am Dr. Bhaskara Mohan, you so and so, we both created a private limited company. That particular private limited company has started a subsidiary. Okay. Now what happens? We both are shareholders in A company. A company is a shareholder in B company. Maybe one or two other persons for that, what you call it, statutory requirement. Then B company is subsidiary of A company. So, section 2 subsection 46 says, holding company in relation to one or more other companies means a company of which such companies are subsidiary companies. Explanation. For the purpose of this clause, the expression company includes any body corporate. It could be, in fact, any body corporate can create another body corporate. Now, what is a subsidiary company? As I told you, subsidiary company is, in fact, under the control of the holding company. Now, subsidiary company's definition is very wider. Section 2, subsection 87 deals with the subject matter of subsidiary company. A subsidiary company is stated to be in relation to any other company, that is with regard to the holding company. Means a company in which the holding company controls the composition of the board of directors. So first one is control of board of directors, or exercises or controls more than half of the total voting power, either at its own or together with one or more of its subsidiary companies. Control of voting power, second point. Shareholding. Provided that such are class or classes of holding companies as may be prescribed shall not have layers of subsidiaries beyond such numbers as may be prescribed under the statute. Then a company shall be deemed to be subsidiary company of a holding company, even if the control referred to in subclass 1 or 2 is of another subsidiary company of the holding company. That's what I told you. ABC, BC will be under the holding company only. The composition of a company's board of directors shall be deemed to be controlled and by another company if that other company, by exercise of some power, exercisable by it at its discretion, can appoint or remove all or majority of the directors. How the board of directors control? By appointing. Company includes any body corporate. Layer means subsidiary or subsidiaries. So with this background, we say that voting power, control of the management, board. By this we can say a company is subsidiary of another company, and that company is the holding company, subsidiary of which company? That particular parent company is called holding company. The other company in which this control is exercised is called subsidiary company. If there are 5 subsidiaries like that, A created B, B created C, C created D with statutory compliances, all C, D, C, B will come under A. A is holding company of B, C, D. This is how it goes on. So I hope now you understand. Again, these subsidiary companies or holding companies could be a private limited company or a public limited company. So you have to understand then what kind of companies it is, what is the meaning of private and public limited companies. That we will see later on. An important aspect I will tell you now, that is foreign company. A foreign company is concerned, it is under section 2, subsection 42. Because a foreign company means any company or body corporate incorporated outside India. This is the most important aspect. A foreign company is incorporated outside India, which has a place of business in India. That is most important again. Incorporated outside India, but having a place of business in India, whether by itself or through an agent, physically or through electronic mode, and conducts any business activity in India in any other manner. So once a company is incorporated in a foreign country and all are Indians incorporated that company there, still it is a foreign company. A company is incorporated in India and all are foreigners, shareholders, still it is a Indian company. Incorporation, place of incorporation is most important. Place of business. So a company incorporated outside India is a foreign company and it has got a place of business in India, then it has to comply with several requirements and then it has to file several returns as the case may be. So what are they? So I will take you through certain important provisions there. For example, section 393. No, 1 second. 1 second. 3, in fact, foreign companies. 2, 393. 383. It starts off. And then 379 is the provision which starts with the foreign company, 379 to 393. 379 to 393. Now, section 379 speaks of the application of the Companies Act to foreign companies. A definition is given already. Section 2, subsection 42. Then the provisions will apply alike. It has got a place of business and then it has to give necessary, file necessary documents with the Register of Companies. And further, there is another important clause that the central government may, by order published in the Gazette, exempt any class of foreign companies from compliances. And where not less than 50% of the paid up capital, whether equity or preference or partly equity and preference of a foreign company, is held by one or more citizens of India, okay, or by one or more companies or bodies incorporated in India, that is Indian companies, or by one or more citizens of India and one or more companies incorporated in India, singly or in aggregate, such companies shall with the provisions of this chapter, shall comply with the provisions of this chapter, and all other provisions of this act may be prescribed with regard to the business carried by it, as if it were a company incorporated in India. This is chapter 22. So section 380 speaks of the documents to be filed with the registrar, and then the accounts under 381, 382, the display of name, etc., stating it is a foreign company, 383 is service on foreign company, and so on and so forth. They are all very important provisions which go on up to 393, where any failure to comply with provisions of this chapter not to affect validity of contracts, and 392 but is the punishment for contravention. That is the most important thing, where it shall not be less than 1 lakh rupees, but which may extend to 3 lakh rupees. And in the case of continuing offence, additional fine also could be levied, which may extend to 50,000 rupees for every day after the first during which the contravention continues, and every officer of the foreign company who is in default shall be punishable with imprisonment for a term which may extend to 6 months, or with fine which shall not be less than 25,000 rupees, but which may extend to 5 lakh rupees, or with both. So this is how it goes on, my dear friends. And then, so friends, you have to go through these particular provisions pertaining to this particular foreign companies. And then, what is that now left out? We have covered foreign companies. We have covered the companies by charter, statutory, registration. Under registration, existing, new. Again, either they could be limited by shares, guarantee, limited by unlimited liability, government, holding, subsidiary, foreign. All these companies could be private and public. So now the question comes, what is the meaning of a private company and then a public company? Please tell me. In fact, it's better, basically, categorically we say a company which is not a public company is a private company, and a company which is not a private company is a public company. No, there is a great variation here. In fact, a private company is concerned, it has got section 2, subsection 68 defines a private company means a company having a minimum paid up share capital of 1 lakh rupees or such a higher amount as may be prescribed as paid up capital, and which by its articles, number 1, restricts the right to transfer the shares. Most important. I told you earlier the conditions. Except in case of one person company, limits the number to 200. Provided where 2 or more persons hold 1 or more shares in jointly, they shall be treated as single member. And persons who are in the employment and hold shares, they will not be in fact covered. And who have been formerly in employment and continue to be members, ceased to be employees, shall not be included. And further, the private company prohibits any invitation to public to subscribe for any securities of the company. I have already explained this particular aspect to you. Only private companies, public limited companies can invite the public to subscribe. Private companies cannot go for public issue. This aspect has been already covered. So a public limited company and private limited company, these are all the restrictions. Then public company means a company which is not a private company and which has a minimum paid up share capital of 5 lakh rupees or higher paid up capital as may be prescribed, provided that which is a company which is subsidiary of a company, not being a private company, shall be deemed to be public company for the purpose of this act, even where such subsidiary company continues to be a private company by its articles. So prima facie, these are all the two things. It is not a private company and minimum paid up capital is 5 lakhs. But what is the major difference? Public company, in order to issue to the public the shares and debentures, the securities, has to comply with several formalities. And then the public company has to comply with several rules and regulations of SEBI and then other things. Whereas it is not the case with regard to private companies. There are a number of privileges for a private company, and then those particular privileges are not applicable to public companies. So the capital base is of no restriction. And then a private company can be converted into public company, or public company can be converted into private company. The deemed private public limited company concept has gone earlier. So friends, with this particular background, what we understand is that a private limited company enjoys several benefits, and the capital base has no limit. But the number of members, shareholders base has a limit of 200. And it restricts, it never prohibits. No company can prohibit the transfer of shares, but private company restricts the transfer of shares. Public limited companies are concerned, the promoter's quota is concerned, there is a restriction with regard to transfer prima facie for a particular lock-in period, but not otherwise. So, you find basically the private limited company and public limited company are two different entities. You want large capital base and public to contribute, you go for public. You have got enough resources, then without compliances, in fact, much compliances, you can happily go for public companies, private companies, and then that would help you better rather than going for all the formalities. So you had to choose as per the size and need as to which company you had to incorporate, whether it is a private limited company or a public limited company with regard to companies by registration. So whether it is a company by share, limited by shares, guarantee, and then government, holding, subsidiary, foreign, and then all these companies it could be a private limited company and then a public limited company. Now, there is one set of companies where the word limited can be omitted. That is what section 8 says. I have already explained. A company incorporated for promotion of art to science, scientific, research and such things. Such companies are meant for public service where dividends cannot be distributed, and then such companies, the word limited can be omitted, and then such particular companies are called section 8 companies, which were erstwhile section 25 companies. So, FICCI, for example, Federation of Indian Chamber of Commerce and Industry, FAPCI, Federation, and in fact, all these particular federations mostly were incorporated under section 25 earlier. Today also, for any purpose useful for public, and then institutions, in fact, are behind such particular organizations, they will incorporate such companies for promotion of science, art, vagera, with regard to section 8. So that is section 8 companies. Now friends, the last part of our discussion, we come to the second segment, incorporated and unincorporated. So what do you mean by unincorporated companies? This is under section 464. It deals with this particular unincorporated companies. Section 464 says that it is an prohibition of association or partnership of persons exceeding certain number under section 464, wherein they are termed as illegal association. If a partnership is with beyond the limit number stipulated, then it is to be registered under Companies Act, failing which it is to be termed as an illegal association. Otherwise, that association could be a society. Cooperative society is society, but it should not be a partnership. For example, no association or partnership consisting of more than such number of persons as may be prescribed. Okay. As may be prescribed shall be formed for the purpose of carrying on any business that has for its object the acquisition or gain of association or partnership by an individual members thereof, unless registered as a company under this act, or is formed under any other law for the time being, but not as a partnership. Under LLP it is different. Limited Liability Partnership Act, again it is different. Provided that the number of persons who may be prescribed under this section shall not exceed 100. It was earlier banking business 10, non-banking 20. Today it is stated as not exceeding 100. Nothing in section shall apply to Hindu undivided family or an association or partnership if it is formed by professionals who are governed by special acts like Company Secretaries Act, Chartered Accountants Act, Advocates Act, and so on and so forth. Every member of an association or partnership carrying on business in contravention of subsection 1 shall be punishable with fine which may extend to 1 lakh, and also person liable for liabilities incurred. So it is called illegal association, and then it would be ultimately called for being wound up. So any partnership which exceeds 100 number would be ultimately a illegal association unless it is registered under the Companies Act 2013 or any other legislation, but it should not continue as a partnership. The concept of LLP is different. It is a separate subject. We have covered it in my introduction, and then that particular aspect is concerned, it is different. So friends, with this background, I conclude our discussion today, and tomorrow, what are the specialities of public limited and private limited companies we will examine, and then we will see thereon. So thank you very much, and then goodbye.